Hello everyone, and welcome again to the second edition of the virtual law lectures here on Star TV. I am Rashid Mbuya, and I'm a lecturer at the University of Sierra Leone, Obe College, Department of Law. We are currently running this program given the frustrating event arising from COVID-19, which has altered tertiary education in Sierra Leone, and coupled with the university administration's call to promote e-learning during this period. And so the management of Star TV, in partnership with Legal Link, are running this temporary program using this platform for the delivery of virtual law lecture to law students in the University of Sierra Leone. Of course, in today's lectures, we'll be looking at the topic rules of statutory interpretation. But let me stress this to all law students, especially in my class. I admonish you to give your full attention, participation and support to this e-learning initiative, as it is a mandate from the University of Sierra Leone through the other department to explore ways that could afford you a better explanation of the notes, as well as an interactive session between myself and you guys. So without doubt, this virtual law lecture series will meet that objective. So I admonish you, if you don't have access now to a television, you can also go to Star TV Online, as well as Star TV Facebook page, or you can also tune to Star Radio. You will watch and hear the program live, and even the Star TV Facebook page, you can see us there live through Facebook Live. And of course, these lectures will also be recorded, and it will be sent via YouTube by the management of Star TV. Let me thank the management once again, Mr. Philip Neville, the director of Media One Center, for giving us this platform, and of course Abdulrahman, who is the manager, for also allowing us to familiarize with the law, the time given to have this virtual law lecture series. And of course, Mr. Ezekiel, who is behind the camera and the engineering box out there. You guys are all great, wonderful. We are grateful, and we thank you so much for doing this for the nation. Again, we are here with a few law students who are here to watch the class and experience it live. And so many of you out there on Facebook TV, today is topic 2. Remember, our last class was topic 1 on the prerogative remedies and orders. Today we are looking at topic 2, rules of statutory interpretation. We are making progress. It's your second semester, so take these lectures very serious. I've given you the notes already, so open to the notes and you will get the explanation from me today. So we thank God again we are here for another great time. So class begins. Alright, because of my social distancing, perhaps I will have to do without the mask for now, so that I can be more audible to you all. Now, what is statutory interpretation? Statutory interpretation. So when you hear the word statutory interpretation, you know the concept, what it really means. Well, it is a process by which a court looks at a statute and determines what it means. So statutory interpretation, in short, is a process through which the court looks at a statute, a law, and determines what it means. Of course, we know what is a statute. It's a bill or a law that is passed by Parliament, which imposes obligations and rules on the people. So Parliament has its own role in the governance architecture of the nation. That is primarily lawmaking. And of course, the judiciary also, they have their own role as well, and that is primarily interpreting the laws and punishing lawbreakers. But then we have a situation where not all parliamentarians are lawyers, or they have legal background. So, and they don't have the responsibility of interpreting the laws, but yet they make the laws. And then the judges are not part of Parliament. but yet they have the responsibility to interpret the laws. So you see where the problem is. One is making the law but not interpreting it, and the other is not making the law but interpreting it. So now there must be guidelines or ways in which the judges who are not part of the lawmaking process can understand really what was the intention of Parliament, or what the wordings of the act that was endorsed by Parliament are as they interpret it. So it's a very serious duty and a very hard work for the judges in the legal environment. So statute interpretation basically refers to the process that they now adopt, to look at statutes and determines what it means. They were not there when Parliament made those laws, but yet they have the duty to interpret them. So it's a difficult one. Now, although great care is often taken in the promulgation of statutes, it is obvious that with the passage of time, laws may become often diverse and subject to many interpretations, and even may contain ambiguities that may require the court's intervention. So, with progress of time, there are many laws that will be passed by Parliament, and because of the complex issues they will be dealing with, they are ambiguous more than necessary, and that itself is a challenge to the judges on how to interpret these laws, especially these new laws that we are getting now for many complex subjects and issues. So statute interpretation is simply the court's process of resolving those ambiguities and deciding how a particular bill or law will apply in a particular case. So that's exactly what it is. So today we are going to look at the different aids, the different things, the different issues, the different concepts that judges rely on to help them interpret laws made by Parliament, that comes before them in a particular case. Remember, they are not part of that, and yet they have a duty to interpret, going to the mind of Parliament as they were making the law. So let's give an example quickly. Let's say we have a law, all right, that Parliament had made that had to do with motor vehicles. And for example, the law says that all motor vehicles traveling on a public roadway must be registered with the, let's say, SLRTC, alright, Aleno Road Transport Corporation. So let's assume a law was passed that says all motor vehicles, so the operative word is all motor vehicles that are traveling on the public roadway must be registered with SLRTC, or SLRSA now, alright. And in the law, there's no section, or there's nothing there that defines what motor vehicles mean. So we say all motor vehicles, but then there was nothing in the law that defines motor vehicles. So Parliament made the law and they inserted motor vehicles, but they did not define what motor vehicles mean or meant. And then that law came to fruition, and then people fell foul of the law. So for example, a person driving a motorcycle that is not registered with SLRSA is pulled by the police. So now the law says motor vehicle, but then a motorcycle was pulled by the police, alright, to say they are in breach of the law because they were riding the motorcycle without being registered. So the individual perhaps who is brought before the court may want to have a defense to say, well, a motorcycle is not a motor vehicle. So that's what the individual may want to rely on. The lawyer for the person may want to say, well, my lord, the law says all motor vehicles, and my client, was caught riding a motorcycle that is not registered. So the lawyer might want to make a strong case that the word is motor vehicle, not motorcycle. So that's perhaps a legitimate defense. Alright, so you may now see that there is a whole problem there, because Parliament had made a law, put a word that was not defined. So it is now up to the judge to now determine whether in fact what Parliament intended, covered also motorcycles and not just motor vehicles. So it is the judge that will have to determine that, and to help him to arrive at a logical conclusion and read into the minds of Parliament, there are rules that will help him. So that's what we are going to look at today, the rules of statutory interpretation. Those things that the judge will rely on. When Parliament had made a law that is a little bit defective, that has some ambiguity, and now the judge, the law is in conflict with people in society, and the matter is before the court. How will the court interpret to know the mind of Parliament at the time? So today we are looking at the aids, the things that will help the judges to interpret the statute, and don't miss the object and purport of Parliament. All right. So the defense will be for that client that, my lord, I don't know why I'm here. I'm having a motorcycle and not a motor vehicle. So that will be a strong defense. So he will say that I'm not covered by the act. All right. So it is now the court that will have to look and see whether in fact Parliament by using motor vehicles also meant motorcycle. All right. It is for the courts to decide. So the rules that will be adopted by judges to interpret the meaning of statutes are numerous, but by and large they have been classified into two broad categories. You have statutory definitions and you have common law rules. All right. So today we are going to look at the set of rules that they will rely on to help them in determining to say, okay, well, this perhaps is what Parliament was intending, and this was not Parliament intended. So it is up to the judges, but they are guided by some rules. So first set is statutory definitions, and then second is common law rules. So let's begin with the statutory definition. So first, there is a general law in Sierra Leone called the Interpretation Act, Act number 8 of 1971 as amended. All right. So many of the laws that are passed today will also make reference to this law. So for example, if there are no clear-cut interpretation of a particular word, all right, in that law, this law, the Interpretation Act of 1971 as amended, will be looked into. So the judge, if there is no clear definition of a particular word and it's ambiguous in the law, the judge will look at the law to see if there are interpretations therein. If they are not, he will rely on the Interpretation Section Act of 1971. That's a general law in Sierra Leone that has many words that will be commonly seen in statutes. All right. So for example, if there is a word, say masculine, all right, so you look at the section of the law of Interpretation Act, it will tell you that masculine gender includes female as well. So for example, if you see a word that is used in the plural sense, it will also let you know that those words can also be used in the singular sense. So that law is a law of general application. So where there are no clear-cut definitions of words in a statute or in a law, the judge will rely on the Interpretation Act of 1971 as a first port of call to see whether in fact those words are defined there. And if they are there, he will use them in helping him to interpret the meaning that Parliament intended under that law. Alright, so that's the first place to go when the words are ambiguous in the statute and where they are not defined. Alright, the second place is called the interpretation section. So here, all modern laws, in fact, it's now the common practice, all modern laws, part of Parliament has a section called the interpretation section. And it's this section that defines and explains words, terms, and expressions that are used in the Act. So you find it most often at the first part of the Act. You see many words, key words that the Act utilizes are defined there. They are defined because Parliament don't want people to misconstrue the meaning of the law or the words that are in the law. So if there are keywords that are ambiguous, there is an effort in some part of the statute or the law that shows their true meaning. So that part is called the interpretation section. So most often, a judge can rely on that part of the law to interpret the words if they are ambiguous. So let's say if the Act doesn't provide that section, he reverts to the Interpretation Act of 1971. But then if it provides, then of course it considers what the section says and the meaning given therein. Alright? So that's another second place or aid to statute interpretation that the judge will rely on interpreting the statute. And the third one, remember this is the broad category of statute definitions. So we have the Interpretation Act of 1971, we have the interpretation section of the Act, and now we have the preamble. So all laws also that are passed by Parliament, they have a section called the preamble. So the preamble gives us a descriptive appraisal of the reason, the purpose, and the object, as well as the scope of the Act. So you will see some some just maybe few lines, 2-3 lines, usually in quote, or usually embolded. So you will see it clearly telling you that the purpose of this law is to it will give some sections and give you some clear sentence and guidelines on what the purpose or the reason of the law is. Sometimes it's about a sentence or two. Alright, clearly telling you. So even if there are no sections to look at that interprets the act, or we don't see the words in the Statutory Act 1971, the preamble itself can help the judge to know what was the reason or the purpose for Parliament passing this law. And knowing that purpose will help you to interpret the statute, at least in a positive way. Alright, so the preamble itself is an aid to statutory definition. So these are the three that comprise the statutory definition. We have the Statutory Act. So where there is a statute that has words that are ambiguous and they are not described in the section of the act, then the judge or the magistrate can look at the Statutory Act 1971 as amended, the general law, to see if those words are there, and then he could now use them in his ruling or in his judgment. Or where they are not there, but he looks at also the act itself, the section of the act itself, then of course that will also help him or her. And lastly, the preamble. Alright, so these three things are very important. Maybe this lecture is also key because I believe many of you, my students, will end up being judges and lawyers. So when you sit there and preside over cases, these are things you should have at the back of your mind. Whenever a law comes before you and somebody is being accused of violating or abusing those laws, definitely you have to work at interpreting the laws properly. And how will you be able to interpret the laws properly is when you rely on these statutory definitions. Look at what the general interpretation law says to find out the right word, because you don't need to guess. So why all this important is because it doesn't want us to guess. Law is not about guessing, it's about facts. So you have to know the meaning of the word as construed by Parliament. Remember, we were not in Parliament when they made the law. Parliamentarians make law, and we are not there, so we didn't know what happened and what we are the mindset as they put those words in the act. So now it is before you as a judge. The first place is to look at the General Interpretation Act, and if it's not there, you look at the section of the act itself, and if it's not there, you look at the preamble. At least you have an idea as to what was the mischief that Parliament intended to remedy under the act. Alright. Okay. So principally these are the three key aids to statutory definitions that is important, and you should take note of that. So now let's move to the common law rules. So the B part of it is called the common law rules. So the common law rules, we have three. We have the literal rule, we have the mischief rule, and we have the golden rule. Okay? The literal rule, the mischief rule, and the golden rule. So at the very least, you have learned about part A, that you have three aids that you can rely on to give you at least the general, meaning of the words in the statute. And I'm sure if you rely on them, you can also help. But assuming, without considering that you don't find these ones as well under the statutory definition, so again, the common law rules will help you. Alright, how you should interpret the statutes, the words in the statute. So let's begin with the literal rule. The literal rule. This rule dictates that words used in a statute must be given their ordinary, grammatical, and literal meaning. So, ordinarily, when a judge is presiding over a case that concerns a law that Parliament has made, a statute, alright, he will look at the words as they are, ordinarily. Alright, so for example, in our earlier case, I'm sure the accused or defendant will go scot-free, because if the law says all motor vehicles should be registered, and then this guy was caught by the police and brought to court because he was riding a motorcycle, I'm sure motor vehicle and motorcycle could have a difference. So ordinarily, if the judge was going to use the literal rule, you will notice that even though the motorcycle was not doing the right thing because he was not registered, But because the law specifically says motor vehicles, the literal ordinary meaning will save the gentleman, the accused, because literally it means we should look at the word as ordinary as they are and their grammatic meaning, the literal meaning. So that will have caused the accused, despite him doing a wrongful thing, act, to have also exculpate and blame. Alright, so the court must apply the ordinary meaning of the words as used in statute, even if it were to produce hardship on the party. So you see, so in this instance, you will notice that he did the wrong thing. It will have really produced hardship on the state. The police officers will say, "Oh my lord, but he was not having a license. He was riding on the highway, alright, without registering to SLRSA." They will have been so annoyed. But yet the judge will say, "I don't care. The law as it is what I will interpret. What is there is motor vehicles and not motorcycle." Alright, so he's using the very tough approach, the literal rule approach, looking at the words as they are and interpreting them without putting any emotion to it. So he will say, "It is not me, it is Parliament that put it there. So I'm going to interpret it as it is, and if they want, they will go and amend it. It's not my business." So no matter the hardship that it will create, the judges will stick by this, and that is exactly what they will do. So this strict view of interpreting, statute was the vogue in the 18th and 19th century. So many judges, in Europe, in the UK, have this strict traditional way of looking at the law. They will not bend. If there is a mistake there, it is up to Parliament, it's their business, but they will interpret it as it is, despite the hardship that it will produce at the end, or despite the miscarriage of justice or the travesty of justice that will be caused. Because we all know riding a vehicle or a motorcycle without registering, driving and riding is wrong. It's something that is not correct. It's a crime, in fact, in our country. But because Parliament perhaps made a small mistake in just saying all motor vehicles are not generally and perhaps motorcycles, or motor vehicle meaning also motorcycle, it's not there, then somebody might just seize opportunity and then misuse the law and go scot-free. So it is very important for Parliament to also note that when they make laws, they have to understand that judges can interpret them literally, and that will might create, hardship for the state, because it may not necessarily mean the effect that Parliament wanted at the time. So I give you an example. Remember, it's a law class, so I will give you cases as we go along. So in the case of Whiteley and Chapel, 1868, this rule was applied and it led to an absurd result. So what happened in this case? So there was a law that made it an offense to impersonate any person entitled to vote. So the law says that it's an offense for any person to impersonate any person. It's an offense to impersonate any person that is entitled to vote. Alright, we have so many laws in Sierra Leone today that also make it an offense. Alright, the defendant impersonated a man who had died and he was still found not guilty, because since a deceased person is not entitled to vote and therefore cannot be impersonated. So this guy was very clever. The law says it's an offense to impersonate any person entitled to vote. So he went and impersonated somebody who has died, who is dead. So eventually he had a reason to participate in the wrongdoing, but yet in court he went scot-free, because when the literal rule was applied, then who can be entitled to vote? If somebody is alive. Alright? So that was a disadvantage, and we all know what it means to impersonate in an election. But yet he went and impersonated somebody who is dead, and he won the case eventually, because he says, "No, I did not impersonate somebody that is alive, somebody that is dead." So the law was a little bit behind time, and he was smarter, and eventually he got his way out. Alright, so we have to be very careful in Parliament when we make laws to be more clearer, because if the judges stay by the literal interpretation, many people who will have done wrong can still go scot-free at the end. Fisher and Bell, 1960, another very important case law where the rule was applied. The defendant was found not guilty when he offered a dangerous weapon for sale by advertising it in a shop window contrary to the act. Under the literal meaning of the term to offer, the defendant was found not guilty, as his advertisement was merely an decision to treat and not an offer to sell. Alright, so he went and displayed a dangerous weapon in his shop, and then of course he still went scot-free, because that was not an offer, as was mentioned in the Act. Alright? It was merely an invitation to treat. It's different from an offer. So when the literal rule is applied, most times you will see people who have done wrong still go scot-free, because Parliament, perhaps because many of them are not lawyers, they don't understand clearly the legal interpretation that will be given to some of these things. So that is why it's important when we make these laws that lawyers are involved. There is, of course, I know the law department is key in this, but when the amendments are done down there, it's good that we also have lawyers who are going to look at the implication, because at the end of the day, it will come before the courts, and the courts sometimes will have to adopt a very literal approach, all right, and close their eyes on what will happen, because it is Parliament who have made the law. So they will look at the natural meaning of the words in the statute and interpret them. All right. Now, but however, in the 18th and 19th century, even though this was the vogue in many jurisdictions across Europe, there was a famous lawyer who challenged this literal rule, traditional approach that judges were relying on. So many cases were going, scot-free. Accused were going scot-free at the end of the day, because judges were relying on this literal rule all the time. And so injustice became the order of the day. And so one judge who was very popular at the time rose up and attacked this whole reliance on the literal rule, and his name is Lord Denning. So Lord Denning is one judge that you will have to have in your head as you are reading law. He's a famous judge in his day in the UK. So in a case called Northam versus London Borough and of Barnet, 1978, he made a very good ruling, and I quote, he says the literal method is now completely out of date. It is no longer necessary for the judges to wring their hands and say there is nothing we can do about it. Whenever the strict interpretation of a statute gives rise to an absurd and unjust situation, the judge can and should use their good sense to remedy it. So he's saying enough of interpreting the laws in a literal sense. If you notice that if you are going to interpret it in a literal sense, it will create an unjust outcome, and it will give the state put the state in a position where the state will lose the matter and create an unjust outcome benefiting the accused, even though we know the accused has done a wrongful thing, very dangerous thing. Then think twice as a judge. Use your common sense, your good sense to remedy it. So he was a very tough judge that was attacking his colleagues in his day. That enough of this. I've seen so many injustice, travesty of justice. People who are guilty because the law has now been interpreted in a literal sense, they are going scot-free. So please, let's stop these judges and let's change our approach. So since then, other forms of common law rules were gradually being adopted by judges, and one of such is the mischief rule. So after this ruling by Lord Denning, many judges start looking at ways to go beyond the literal rule and now adopt other positive common law rules to interpreting statutes, and that's how we eventually saw so many cases on the mischief rule and the golden rule. So the second one is the mischief rule. So the mischief rule came from the Hiddon's case of 1584, and it clearly dictated four points that were laid out in this case that the court should consider when interpreting statutes. So first, it should ask what was the common law before the act was passed, what was the mischief and defect for which the common law did not provide, what remedy had Parliament resolved to provide, and what was the true meaning of the remedy. So a judge must ask himself all of these questions, before now making a decision as to which, rule to apply. So under this rule, once the court has examined what the intention of Parliament was in passing a specific act, identified the mischief which the statute was seeking to correct, they must interpret it in a way that addresses the gap, that is the mischief. Alright, so the court is under a duty to interpret the statute in a way as to suppress the mischief and advance the remedy. So the mischief rule is saying, look at the intention of Parliament. So go beyond the words. Look at the intention. What was Parliament intending to remedy, to correct as they were passing this law? It's a very difficult one. So the judge will not just stop at the literal meaning anymore, because the literal meaning will might create hardship. So if they come back to my first scenario, the all motor vehicles versus the all motorcycles, motor vehicle, motorcycle. Now, if the judge was to interpret the law literally, of course, the gentleman will go scot-free, not so, sure, because he has a motorcycle, and in all sense, it's different from motor vehicle. But assuming the judge was now going to use the mischief approach, so will that gentleman have gone scot-free? The mischief approach, the intention of Parliament, surely he will not have gone scot-free, because the intention of Parliament was to make sure that vehicles on the road, whether cycle or vehicle, they are all licensed with SLSA. Alright, to prevent unregistered, means of transportation plying the road, because that will create accidents. So the intention there was to cut down, this illegal movement of persons on vehicles, and that was the intention. So it's irrelevant whether it's a cycle, a bike, or a motor. It's irrelevant. So in the intention, you are going beyond the words to look at what was Parliament trying to curb as they are doing this law.
It's a common sense approach.
Yes. So it has to do with your senses. You judge the mind of Parliament at the time as they were making law. You don't listen to the words in statute, because otherwise they might create hardship and cause people to go scot-free even though they have committed a crime. Okay, so it's a very good way of interpreting statute, the mischieful. So there's a case law I want you to know. It's called the Smith Hughes and Hughes 1960. The State Government Act of 1979, under section 1 of the Act, it makes an offense to solicit in the street for purpose of prostitution. So let me take it again. Smith versus Hughes 1960 is the case. Smith versus Hughes 1960, and the Act was called the Street Offences Act, okay, of 1959. So under this Act, there's a section that says it is an offense for anyone to solicit in a street for the purpose of prostitution. So anybody that engages, in soliciting in a street for prostitution, you'll be found wanting under the Act. All right, that's section. So what happened? The defendant, did this and was caught and was prosecuted. So he argued in court that she was not in breach of the Act, as she was using her own premises to attract bypassers and not physically standing in the street. So there will be people who want to raise defenses all the time on laws passed by Parliament. They call it de minimis, to find the mistakes. So the law says it's an offense for you to come to the street and solicit. So what she did, I'm sure her house would have been close to the street. So she stood in her premise and she was soliciting, asking people to come for sex and all of that. Alright? So she was caught and then she was prosecuted. But then in court, her lawyer was defending that. No! The law says if you are doing it in the street, she said, I'm doing it in my house, premise. So you see, if we interpret it literally meaning, I'm sure she'll be free, not so?
Yes, sir.
Because street and premise are different. So what the judge did in this instance, the judge looked at what the law was intending to remedy and held that Parliament's intention was to clean up the streets and prevent people who are innocent from being pestered by prostitutes. So the defendant was found guilty as charged. So he says, okay, I agree your defense is a little bit solid, but I'm looking at the intention of Parliament. What they intended by this law is to stop people like you pestering people who are passing the street for prostitution. That's the intention. So whether you did it in your premises, as long as it's a people passing by, that is the remedy Parliament wanted to curb in the law. Are you understanding me?
Sure.
So you see now, when you interpret it literally, she will go scot-free, because in the street and in the premises are two different things. But when you interpret it from the mischieful perspective, the intention of Parliament, she will be found guilty, because it was to prevent them being pestering people who are passing by, all right, who have other things to go and do. So whether she was in her house calling on them, is irrelevant. Parliament wanted to suppress prostitution in the street, all right, prostitution, all right. That's the intention. Okay, is that clear?
Yes.
But most times it's a difficult thing to know the intention of Parliament by judges. So there are things that also can help them to understand the intention. One is called the Hansard. Okay, Hansard. So basically, they will look at it's a document that is in Parliament, so it contains the argument, all the things that we have said in the whole debate as they formulate the law. Okay, they are kept in Parliament. So a judge might also want to look at the Hansard. What was the argument? How did they arrive at getting at this law? That will also inform the judge to know the intention. Because how can you know the intention when you're not there? Alright, so the Hansard can help judges to really know the intention and then definitely interpret the law using the mischief rule. Okay, let's end with the golden rule quickly, and then I can take some questions. Now the third one is the golden rule. So again, for recap purposes, if you're out there watching us live on Star TV, this is topic 2, rules of statutory interpretation on your law notes for year 1 student, Department of Law. But if you're also a law student out there, why not? You can flow with us and understand. And of course, if you are a citizen who is interested in the law, definitely this is also a program for you. Because when you know your rights, you know the law, you can be able to claim your rights easily and defend them when they are threatened, when they are abused, or when they are violated. So the third rule today we'll be ending with is called the golden rule. So when we talk about the literal rule, we mean the judges are interpreting the law as they are in their ordinary grammatical meaning. When we talk about the mischief rule, they are looking at the intention of Parliament. What was Parliament trying to remedy, alright, as they were passing this law? So they look at the intention, not the words, not the ordinary meaning of the words. Now, what is the golden rule? Alright, so the golden rule is effectively used to prevent inconsistency and absurdity when interpreting and acting literally. The golden rule allows the court to modify the words in a statute so far as it's necessary to avoid the absurdity or inconsistency. This is a very radical one. Although some judges are of the firm belief that statutes are not to be applied literally, no matter how absurd the concept might be, more liberal judges have, however, maintained that when the meaning of the words in the statute are uncertain or ambiguous, and where the application of those words will lead to absurdity or inconsistency with another part of the statute or general principle of law, the golden rule allows the court to modify the words so far as it's necessary to avoid the absurdity or inconsistency should be adopted. So this is a radical one. So it's saying, this rule is saying, if you realize that the words in the statute, if you interpret them literally, will create inconsistency and absurdity to the general law and other principles of law, modify the word. So this one is a very radical one, because you are trying out to say amend the word, amend the law for Parliament. It's a very radical one. So here, this rule, if a judge adopts this rule, the judge will go as far as modify the word. So if there's a mistake there, he will change the word. It's a very radical one, the golden rule, because it's all about trying to get at justice. It will not allow the inconsistency and absurdity to fester. It will attempt to change or modify the law.
That's tantamount to.
Yes, I'm coming to that. There's a whole problem with this, but it tells you how liberal judges were becoming radical in getting at justice. That they're not to wait, and injustice continue to fester while Parliament does nothing. They have a duty to do an extraordinary thing to get at justice, even to touch the law and modify it. It's a very radical one. So you see, they will modify it to the extent that the absurdity is being cured at the end of the day and justice is being served. It's a very tough principle. Let me give you a case. Alright. So in Gray vs. Pearson, this position was re-echoed by Lord Wensleydale. In that case, it says, let me just quote what it says. This is very important in that case. It said the grammatical and ordinary sense of the words is to be adhered to, unless that will lead to some absurdity or some repugnance or inconsistency with the rest of the instrument, in which case the grammatical and ordinary sense of the words may be modified so as to avoid the absurdity and inconsistency, but no further. So in this case, it was held. So it's a principle of law that says in that case that judges can modify so long as the grammatical interpretation might lead to an absurdity. Alright, so it's a very radical one. Let me give you another case that we saw this happen. A judge modified the statute. It's called the case of Resigworth. So your locus classicus case for the golden rule is Resigworth, 935. Resigworth, Resigsworth. Now the facts of this case. In this case is a son murdered his mother a son murdered his mother in order to inherit the deceased estate. So ordinarily, by the words of the statute, the next of kin will inherit the deceased estate. So there was a law that says the next of kin will inherit the deceased estate. And so this son who saw this law and was a very greedy son and went to exploit the law, he went and killed his mother. His mother, I'm sure his mother will have had some estate, and he noticed that the law was in the country that says the next of kin will inherit the deceased estate. So he went and killed the mother to inherit her estate, because I'm sure he was the next of kin. So the matter was brought before a judge. I'm sure he was found culpable on this, and he was brought before a judge. Alright, and now look at what happened. The judge realized that if he interprets this law in the literal sense, this murderer will benefit out of his illegality. Alright, because the law says the next of kin, and he was next of kin. So what the judge did is that he applied the golden rule and held that the next of kin will not inherit the estate where they had killed the deceased. So he put some words into the law, where they have killed the deceased. See? So the radical thing he did. So he said they will not inherit it where. So he put new words, where they had killed the deceased. He modified the statute because he didn't want the son to benefit from the mother's estate when he is the person who has killed the mother. So you see, the law was saying, the law was open-ended, it was vague. But yet, the facts before the judge were that if I follow this law, this son will benefit from his crime. So he had to modify it, say, no, where they had killed the deceased, they will not benefit. Are you understanding me?
Yes, sir.
Very radical law. Receive what? Very nice case to look at, okay? So that is it. It is a very tough decision. Judges are always going to be confronted with this. You don't know, one day you might be a judge or a magistrate. You have to follow these things. You have to look at the circumstances. So don't just look at the literal meaning all the time, because it might create absurdities. Go beyond the literal meaning and look at the intention of Parliament. And perhaps where in fact the intention of Parliament and literal meaning might create absurdity, you go beyond to even modify and make sure you get a justice. Because at the end of the day, you don't want to defeat the cause, the ends of justice. That is the goal of a judge. You are working towards justice, and justice must be served. You are going to make sure all you're doing is getting a justice. So it may require to even modify the statute, as in this case. I'm sure we will not be angry with the judge, not so? Will you be angry with the judge?
Answer.
I'm not sure you will be angry with the judge, because it served the interest of justice. It was not a good thing to see the son who had killed the mother inherit her estate. Alright, so it's about the ends of justice. Okay? Let me conclude by saying this, that these three common law rules, as good as they are, they have their downsides. Alright? Not so? You agree with me? Not so? Now, so it will be incorrect to say the above common law rules are without flaws. Alright, from the various analysis that we have given, it is clear that literal rule can cause absurdity and unjust results where it's applied in the strict sense. Also, if we apply the literal rule in the strict sense, there will definitely be absurdities and it will create an unjust result. If we say we are going to follow the law that says all motor vehicles, then all motorcycles, keke, all into them, they all go way inside and do one thing there. And they will say, well, we are all part of it. And at the end of the day, they will go scot-free, even though they have not registered. So when you follow the literal rule strictly, there will be an absurd result, unjust outcomes at the end. So that is the downside. Now, under the mischief rule, judges may not always be clear as to what the draftsman intention means or what Parliament intend, and they might even interpret it exactly the opposite of what the law perhaps at the time they meant. So it's a difficult thing to read into the minds of Parliament. So that's the downside of mischief rule. It's good, not so, to go beyond the words and interpret it looking at the intention. But then, can you always get the intention? Were you there? Can you read into their minds? That's the difficult thing as well, and the downside perhaps of the mischief rule. And the golden rule, of course, modifying the phrase of the words by a judge is a clear usurpation of the powers of Parliament. Remember, the statutory body, the constitutional created body is Parliament to make laws. Also, it's Parliament. So Can we see now the judge trying to make law, to change the law, to amend the law, all right, without reference to Parliament? That is also something that people are crying and say, well, this radical way of interpreting statutes might lead to also, a conflict with the role of Parliament and the judiciary, because Parliament is the body that amends laws, not the judiciary. All right. So in that sense, that's also a downside of the golden rule. As good as it is, it has a clear downside. And don't forget, Parliaments are democratically elected. All right, and judges are appointed. So people are saying, well, how can an appointed mechanism, have the sole right to amend what a democratic mechanism ought to have done? So there's also that argument of undemocraticness in the whole ball game under the golden rule. So in essence, none of these common law rules are without defects, as good as they are. All right, that's what I want to understand. But what we have learned today is that these rules will help the judges, will help the magistrates, and it's important that we follow them. So tomorrow you might be a judge or a magistrate, and I hope that you will consider all of this even as you interpret a case or a statute that deals with a case before you. All right. Okay. Question time quickly.
Yes, sir.
Yes.
For a curious listener might want to ask, between the literal rule, mischief, and that of the golden rule, which one is more appropriate to be used by the judge?
Well, it depends on the circumstances. All right. It depends on the circumstances and the fact before the judge. That is why it's important that we all understand these different aids to statutory interpretation. We have the statutory definition and we have the common law rules. So now that you know, you can now be able to understand which particular rule perhaps might give the best outcome to arriving at justice. Remember, the end goal is arriving at the ends of justice. All right. So use the particular rule that will not defeat the object and purpose of the act. All right. Yes.
Yeah. Just to clarify, I'm not a law student. I'm just a curious television anchor. Well, basically, another downside of this particular concept that you fail to mention is it has manifold implications. It has the possibility to really usurp the will of the people, because Parliament is a house that represents people. But if this particular concept is giving a judge the latitude to modify the law, it means it's also usurping the powers of the people. I mean, are there any safety guards to ensure that when a judge misinterprets or goes beyond overboard, that could be a possibility in which they could do? There's a safety guard that could look at the oversight of the judge.
Yes, I agree with you, because they probably call it judicial activism. When the judges want to go to a point of, trying to amend the law, all right, it's a radical way of doing it. It's judicial activism, all right. But many people have commended that approach as well, because remember, it will take a lot of time, all right, to send back the law to Parliament for amendment, okay. All right, and who knows whether in fact they will agree. So, and the hardship and the injustice and the opposition will continue to fester. So the judge will, most times it's not really the vogue. Judges are hardly to take the golden rule approach. But they can count the cost to say, okay, will I have to wait? These people are dying, and then send this law to Parliament for amendment, where I know there is a fight as it's going to take place, and perhaps they will not even amend the law. So I will look at the balancing act between the delay and the imminent danger that is festering on, that I intend to cure. So that is where judges can be, judicial activities can come in, and then say, you know what, I will modify it to cure it. And the Parliament can also call for the law and perhaps also overturn and amend, all right, or amend. Okay, so it's up to Parliament, or to do a new law to now capture this radical modification into a legal framework which they can approve. All right, but most times it is not like they can even give the time frame. Say, okay, I will insert this clause for 1 year, and until Parliament now adopts a new law. It's not about just being radical to make sure justice is served. There is no travesty of justice, and there is no delay in getting at justice at the end. They can be, and this is usually the case in many countries across Europe and even South Africa. South Africa is radical for these judgments. You see, judges are going beyond modifying and setting the time frame. So, okay, in 1 year time, this should be what the law should look like until Parliament, adopts a new one and review. So when the 1 year elapses, they trust that Parliament will have done their work to have a new law that takes on board all of this. And most time when they do so in good faith. Okay. You will see that indeed it was necessary for the judge to have done that, because otherwise there will be a travesty of justice. I also note your point, but I think I said something about undemocraticness of the two organs of government. All right?
Yes, sir.
Yes.
Commissioner, sir, between the statutory definition and the common law rules,
yes,
which one should be given preference?
Yes, I agree with you. It's a whole ball game, but I think you should start first with the statutory definitions. Look at them, because they also they are aids to statutory interpretation. If the law itself has a section that interprets its words, then why are you going to waste your time? Look at what it says, not so, okay, and then import that and then interpret the law. All right, yes. So, do we have any comments from the Facebook guys out there? Yes, quickly. Let's hear one or two quickly. Any question from the Facebook people? All right. Do we? You sent it to him? Yeah. Your questions, yes.
Yeah, most of the questions you already.
Yes, say one or two. Let's get their views.
Well, this one is asking, what are the main rules of statutory interpretation between the mischief rule, literary rule, and that of the golden rule?
Okay, I think that is answered. Yeah. Go next one quickly.
Then the other one says, the difference between common law and that of statutory law.
Okay, it means the common law rules and the statutory definitions.
Yes.
Okay, answer again quickly.
The other one is saying, what's the difference between the golden rule and that of the mischief rule?
Okay, one more.
Then the other one is saying, why is there a need for statutory interpretation?
Okay, good. I think these are two questions that I can answer quickly. So the golden rule and the mischief rule, the difference is that in the mischief rule, the judges look at the intention of Parliament to determine what was the remedy that they intend to advance, and then they suppress the mischief. All right, and then of course the golden rule is where the interpretation of the word might lead to absurdity. The judge can have the leverage to modify the words to the extent that it cures the absurdity, all right, and inconsistency, all right. And then of course the importance of all of this is that it will help for judges to interpret statutes in a correct way and eventually get at justice. Remember, if these aids are not there, how will the judges and magistrates be able to understand all what Parliament has done in all the plenty of laws that we have in the country? Exactly. To be a difficulty. That's why you have these statutory definitions and common law rules. To help, they call them aids to statutory definition. It helps you in arriving at how to interpret the law as you deal with the cases before you. Remember?
Yes, sir. Final one is, does the statute override the common law? Final question.
Okay, this is a very nice one. So, so in our jurisdiction, of course, there are different sources of laws. All right, we have the Constitution. So when something happens, the first place of call we may intend to look at what the Constitution says. Is the government the highest law? All right. Second is the legislation. All right, and then we come to common. So there are all sorts of laws, but in their hierarchy, I'm sure legislation surpasses the common law rules. All right, common law sources, because at the end of the day, it is also, remember, it is, although common law is part of our laws, but statutes are ours. Common law can even be of course they are the sources of they are the customary law of England, all right, but they have been adopted by us in Sierra Leone. But in the stratum, in the hierarchy, legislations can be relied on, all right, much more than common law rules, all right, common law sources. Okay, yes. So that's it for today. Well, if you are out there, viewers, I'm sure you have learned something today. My students, we have completed topic 2, rules of statutory interpretation, and I hope you have enjoyed the class for today. Our next class will also hold, you'll be communicated on the time, but remember, on Thursday, switch in also and get the repeat. So this program will be repeated on Thursday as well. Tonight, in fact, at 11, and then of course on Thursday you will get the repeat. So go back and study notes. I've sent the notes to your WhatsApp groups. Read them again. These expressions can help you greatly to see how judges struggle, many a times. So when you see judges are making a judgment, these are the things that they go through. It's difficult to understand what Parliament intended in the law. So please don't blame them all the time. It's a difficult thing, and in case you want to aspire to be a judge or a magistrate someday, understand that these rules are there to help you to arriving at a just conclusion of a matter. So see you again next week perhaps Thursday we have the repeat. and you will see me next week on topic 3. But you'll be duly informed. Your class rep is here and the assistants. So it has been a wonderful time. The link will be sent to you in case you missed this program, also on your WhatsApp group. It's recorded live on Facebook. Thank you once again. I'm Rashid Dumbuya, and thanks Star TV for hosting us again for another virtual law lecture series. We are grateful. Thank you.
Law for Non-Lawyers is an open education program run by LegalLink in partnership with Star Television to help law students offering law-related courses and other interested citizens such as human rights activists, journalists, accountants, politicians, religious leaders,